This leads me nicely on now to the final section of the webinar, and this is really probably the most important points to note going forward. And this is just the practical tips for organisations and some things that organisations can consider doing now before the end of the transition period to ensure that from the 1st of January 2021 you are data compliant. So firstly, I would recommend re-familiarising yourself with your organisation's data flows. Hopefully, as part of your initial GDPR preparations back in 2018, you carried out a detailed data mapping exercise. And the data mapping exercise would really have set out to whom and to where you're sending and receiving personal data from. Knowledge is the key to compliance, because if you don't know where you're sending and receiving personal data, particularly any material data flows, you're not going to know what steps you need to take in order to ensure that your data flows can continue lawfully from the 1st of January 2021. I appreciate back in 2018, organisations had a lot to contend with in terms of GDPR compliance. So even if your organisation did not carry out a substantive data mapping exercise back then, it isn't too late. There's still a few months before the end of the transition period. And a data mapping exercise really is an effective tool for just displaying all of your organisation's data flows and also in highlighting any data flows that may present a particular risk. So for example, based on the nature and extent of the data being transferred and also to the particular location that the data is being transferred to. Secondly, I would recommend identifying existing relationships and data flows, including those with customers, suppliers, or group companies that may involve the international transfer of personal data. So you should review any relevant international transfer provisions and/or mechanisms and assess whether any amendments may need to be made to cater for Brexit. And this includes any amendments to contractual documentation. And this is usually a relatively straightforward exercise that will just involve tweaking the data protection legislation definition and also possibly the international transfer clause. You also should consider over the next few months whether you're going to need to implement any appropriate safeguards. Most likely this will be the standard contractual clauses. So after you do this, you're then going to need to determine which set of standard contractual clauses will apply to each of your data transfers. As I discussed when going through the standard contractual clauses, you're going to need to carry out some degree of due diligence in relation to the laws of the recipient country to ensure that they offer sufficient protection. And this is in light of the Court of Justice of the European Union's decision in Schrems II. In practice, the other party should be able and willing to assist you with this, because it's in both parties' interests to ensure that the data flows can continue lawfully. And just on this point, you should also review any data transfers with the US and check if you will also need to implement standard contractual clauses for those as well. It's also important to keep records. I haven't put that up on the screen, but just as a minor point, you should keep written documentation of any standard contractual clauses that you put in place. And as I've mentioned, the standard contractual clauses are going to be updated. Organisations are taking a different approach to this. So some are opting to hold off and wait until the updated clauses are published before putting them in place. This is ultimately a business decision following a risk assessment of the potential implications of not being prepared by the end of the year. But I would say if you do want to hold off in the hope that the new updated clauses will be in place before the end of the transition period, you should ensure that you are familiar with all of your data flows so that once the updates are made, you can hit the ground running and act quickly. But the key point to take away is that you must ensure that your organisation is compliant by the end of the transition period, meaning that if you are transferring data to the US or if you're going to be receiving personal data in from the EU, then you should ensure that you have one of the appropriate safeguards in place, or failing that, you can say that a derogation will apply under Article 49. You must keep up to date with the guidance The ICO and the European Data Protection Board are very good at publishing updates. The ICO has said that it understands the many challenges that businesses are facing at present, particularly in light of COVID-19. But this doesn't mean that the ICO is refraining from carrying out its enforcement function. Therefore, it really is paramount that you are familiar with current best practice and guidance. You also need to be proactive and act now so that your organisation is prepared for the end of the transition period and the EU exit. And this will also help instill confidence within the organisation that it is compliant. As you will note, knowledge is key, and once you're familiar with your data flows, the next steps are going to be more straightforward. For example, implementing standard contractual clauses. And as I've just mentioned, the ICO has wide-ranging enforcement powers, and it does take a very firm approach to data breaches and also to non-compliance, including non-compliance with the administrative requirements of the GDPR, and many hefty fines have been issued, with potential liability extending to the higher of 4% of global annual turnover or 20 million euros. My final slide just outlines some useful links for you that provide more information on the data protection implications of EU exit. You will see from the links that the ICO website is absolutely fantastic. It covers basically all the queries that you could think of in relation to EU exit, and it is updated, so that's definitely a tool that you should be keeping an eye on. Also, InvestNI have a fantastic range of resources. They have an FAQ section, which again, they do update as more guidance comes to light. Gov.uk as well has quite useful information, and the European Data Protection Board also has a good practice note on data transfers following EU exit. If you do have a specific query or a niche issue that you want addressed, well then don't be afraid to go and obtain specific legal advice, because the penalties really are too high to risk non-compliance.